morning to all of you. Myself Deepika S, our first MSc Chemistry, your host today. I'm pleased to welcome you all on behalf of the Department of Chemistry, Holy Cross College Autonomous, to this webinar on the role of IPR in innovations. Dear participants, please mute your audio and video throughout the session. We shall begin the session by invoking God's presence through a prayer song.
நீங்காத உறவில் நிறைவான உணர்வில் நீங்காத உறவில் நிறைவான உணர்வில் இறையே உன் நிழலாடினேன் அடியேன் என் நிலை மாறினேன் நீங்காத உறவில் நிறைவான உணர்வில் இறையே உன் நிழலாடினேன் அடியேன் என் நிலை மாறினேன் உன்னோடு கைகோர்த்து நான் செல்லும் பாதை அழகானது தினம் அழகானது உன் கண்ணோடு கண் சேர்த்து நான் பார்க்கும் பார்வை புதிதானது தினம் புதிதானது உன்னை ஏற்றுக்கொண்டேன் ஒரு மாற்றம் கண்டேன் உன்னில் உலகை புதிதாக கண்டேன் நீங்காத உறவில் நிறைவான உணர்வில் இறையே உன் நிழலாடினேன் அடியேன் என் நிலை மாறினேன் நிதம் காணும் வானம் நிலையான போதும் அதில் தோன்றும் மேகம் இடும் கோலம் மாறும் நிதம் காணும் வானம் நிலையான போதும் அதில் தோன்றும் மேகம் இடும் கோலம் மாறும் மாற்றங்களை மனம் தேடுதே உந்தன் வார்த்தைகளே உரமானதே மாற்றங்களை மனம் தேடுதே உந்தன் வார்த்தைகளே உரமானதே இறைவா இறைவா வாழ்வு உன்னை வளமானதே நீங்காத உறவில் நிறைவான உணர்வில் இறையே உன் நிழலாடினேன் அடியேன் என் நிலை மாறினேன்
Welcoming is an art that comes from our heart. It's my pleasure to call upon Dr. Sheba Daniel, Assistant Professor, Department of Chemistry, to deliver the welcome address.
A very warm good morning to the participants of this webinar on role of IPR in innovation. It's my indeed pleasure to welcome you all cheerfully to this webinar. In this occasion, I would like to welcome our secretary, our principal, our vice principal, and the controller of examination. On behalf of the Department of Chemistry, I accord my cordial welcome to you, dear sisters and dear ma'am. Life become monotonous in the absence of creativity and innovation. At this juncture, I would like to welcome and introduce our today's resource person, Ms. R. Hemalada, Assistant Controller of Patents and Designs, Biotechnology Division, the Patent Office, Government of India, Chennai. She did her postgraduate degree in microbiology and pre-doctoral research in marine biotechnology. She joined as Examiner of Patents and Design in Indian Patent Office, Government of India in the year 2003 and got promoted as Assistant Controller of Patents and Designs in the year 2015. Her nature of work is to examine the patent application in various branches of Patent Office in India and disposing the applications based on the merits like granting of patents and refusal of patent, etc. We are indeed fortunate to have such an eminent person in our midst to address on innovation and IPR. On behalf of the Department of Chemistry, I extend my most cordial welcome to you, dear ma'am. Moving on, I would like to welcome our respected head of the department, Dr. G. Lima Rose, and all the other faculty members of our department who are the backbone of all our activities and does multiple tasks with enthusiasm. I accord my hearty welcome to dear ma'ams. Last but not least, I would like to welcome the young and energetic future innovators from our department who are eagerly waiting for the upcoming fruitful session. On behalf of the Department of Chemistry, I extend my cordial welcome to you all, my dear students. Once again, I welcome you one and all. Thank you.
Thank you, ma'am, for your warm words of welcome. Now I hand over the session to our resource person, Ms. R. Hemalata, Assistant Controller of Patents and Designs, Biotechnology Division, the Patent Office, Government of India, Chennai. Over to you, ma'am.
Morning to all. I'll start up with the session. Today's topic is role of IPR in innovation. Role of IPR in innovation. I'll first give an introduction to what is innovation. Innovation is defined as the change that adds value and happens when someone improves on or makes a significant contribution to something that has been already invented. So what is innovation? Innovation is a improvement or significant contribution to something that has been already invented. So a product or process, what is already present in our system, when you are making a significant contribution to that, it leads to innovation. Hello, it leads to innovation. What is invention? Invention is the creation of a product or introduction of a process for the first time. Invention is defined as new and novel. Novelty is an essential part of an invention. So, when there is an invention, if you make a significant change or if you make a significant contribution to whatever is invented, it leads to innovation. Next, novelty is an essential part of an invention. That is, invention should be novel. It should be new. And next comes a important topic, that is creativity. What is creativity or creation? Creation is the tuning of new thing, new idea. Creation is the tuning of new idea. So there is a very vast difference between these three terms. What is innovation? What is invention? What is creativity? Innovation is the process of tuning a new concept into commercial success. Invention is the creation of new idea or concept. Creativity is the act of tuning new and imaginative idea into reality. That is, creation is the coming up with new idea. Innovation is executing the idea, converting the idea into successful business. All these terms are interrelated, and these creativity, invention, innovation leads to the growth or increase in the economic of a country, and it leads to the growth of a business or any research. So our topic today is Just I'll go back to the first slide. Our topic is role of IPR in innovation. Now we saw what is innovation, what is invention, what is creation. This creation is the leads to IPR, intellectual property right. That is creation of mind. So I'll start from very basic. What is property? Property is of two types. One is tangible, another one is intangible. Tangible property is of two types. One is portable asset, another one is stationary asset. And intangible property, that is the intellectual property. What is the creation of mind? Intellectual property is of two types. One is industrial property, another one is copyright. Industrial property covers patent, designs, trademark, and geographical identification. Intangible property, it covers intellectual property. That is, intellectual property is the creation of mind. And this intellectual property is of two types. One is industrial property, another one is copyright. Copyright covers patents, designs, trademark, and geographical indication. These are all formed because of a new idea or innovation in your is the creation of mind. Next one is copyright. So, as I already said, intellectual property is the creation of mind, which covers patents, trademark, geographical identification, copyright, industrial design, trade secret, layout design of integrated circuits, plant variety in force. Now, I'll discuss one on each topic separately. What is copyright? A definition for copyright. Copyright is the exclusive right granted to the owner for his or her literary, artistic, scientific work to use. He can use, or he or she can use by himself, or authorize others to use it for its reproduction, public performance, translation, and adaptation. So, copyright is the exclusive right granted to a owner for his or her literary, artistic, scientific work to use, or authorize others. He or she can authorize others to use it for its reproduction, public performance, translation, and adaptation. That is one criteria. Main criteria to get copyright is, the condition to register for copyright is it should be original. So copyright is given for, this is a slide showing where copyrights are applicable. It is, copyright is given to writings, sculptures, paintings, literature, choreographic work, maps, cinematographic work, technical drawing, translation work, computer programs, multimedia works. These are the places where copyright is applicable. Next comes the important topic, trademark. What is trademark? You might have seen this trademark symbol in most of the products what we are using. That is the trademark, what registered trademark will be identified by R marking T. And what they have registered now, it will be marked by TM. What they have already registered is marked as R. That is, you might have seen in most of the product what we are using in our daily life. This trademark, these are the different trademark symbols. And what is trademark? I'll define what is trademark. Trademark is any sign which can distinguish the goods of one trader from those of others. So what is the basic necessary for trademark? Trademark is nothing but a sign. Sign includes words, logos, pictures, or combination of these. And what is the purpose? It will, one trademark symbol will distinguish your product from that of other person's product. So it is used as a marketing tool so that the consumer can recognize the product by the word, logo, or picture. That is the basic use of a trademark. So trademark is nothing but it's a sign which can distinguish goods of one traders from those of others. This sign includes words, logos, pictures, or combination thereof. What is the purpose of this trademark? It's a marketing tool so that customers can recognize the product of a particular trader to differentiate it. And To register a trademark, the mark should be distinctive, non-deceptive, or contradictory to law or morality, not identical or similar to any earlier marks for the same or similar goods. So it should be unique. The trademark, if you are having any trademark related to a business you are having, the mark should be distinctive, it should not be deceptive or contradictory to law or morality. And the main point is the mark what you are having, what you want to register for trademark should not be identical or similar to earlier mark for the same or similar good. Next comes the designs. The picture shows different designs for cars, car seat, jars, and different model of chairs. That is industrial designs. Industrial design. What define industrial design? Industrial design is the concept of an useful article which is ornamental or aesthetic, two-dimensional features like patterns, lines, colors, etc., and three-dimensional features like shape, surface of an article. So design is given for given in two angles. One is which is ornamental or aesthetic. Ornamental and the two-dimensional features like any lines, color shades, three-dimensional features like shapes, surface of the article, etc. For these things, industrial designs are applicable. For example, shape of a handle or body portion of a pressure cooker. The body portion, that is the design of the handle and the design of the pressure cooker, industrial designs are applicable. And here also the design criteria for getting a design is getting a design registered is the design should be new or original and industrially reproducible in form to become eligible for protection. And next comes an important topic, geographical identification. These are the pictures for which the Government of India has given geographical indications. For example, this is Tanjore dolls, Darjeeling tea, Tanjavur Kanjipuram saris, and the paintings, and Nagpur orange. So, what is geographical indication? Geographical indication of goods are defined as the aspect of industrial property. Geographical indication is also an industrial property which refers to the geographical indication referring to a country or a place situated therein as being the country or place of origin of the product. So, to say in simple terms, geographical indication is given to a group of people living in a particular community based on the origin of their product. For example, the Kanjipuram saris, the specified nature of this Kanjipuram saris, for that they have given the geographical indication, that is based on the origin geographical locality region of the product. It is given to a group of people, that is based on the particular community of the people. This is geographical indication. Next, what is the criteria? The geographical indication marking must not mislead. It should lead to economical prosperity. For example, as I said, Kanjipuram silk got geographical indication, Darjeeling tea, Basmati rice, Kolhapuri chappals, Nagpur orange, etc. Next, the very important topic what we are going to discuss today is about patents. Patent. I'll discuss the patent topic in detail. What is patent? Patent is the exclusive marketing right given by the government to the patentee for a limited period of time for commercial gain in considering the full disclosure of the invention. So, patent is an exclusive right given by the government to whom? To the patentee or inventor of an invention for a limited period of time, that is for 20 years. When he or she discloses his invention to patent office, based on the merit, patent is given by Government of India for a limited period of 20 years. And this is the picture showing how it is being given. Person, that is the inventor or assignee, he is disclosing his complete invention to the patent office. That is the document is the techno-legal document which should satisfy novelty, inventive step, and industrial applicability. And in return, an agreement is made between the inventor and Government of India for 20 years, so that in this 20 years period, he can commercialize his product. He can not only commercialization, he can go for a royalty, some etc. So, what is the patent? Patent application is a techno-legal document. It should satisfy three criteria. One is novelty, another one is industrial inventive step, and industrial applicability. So, why patent? What is the necessity of getting a patent? When you are doing a research, you can get a patent, you can develop it, market it, get profit out of it, reinvest the your particular invention. Next, in wider range, an industry after getting a product, a patent, it can go for new service, it can improve the society, and the new product will exist in the society for the improvement of economy of our country. So, after getting a patent, development getting a research, if you're having a research paper, you can file for a patent. After getting the patent, you can develop it, market it, get profit out of it, reinvest it in your research itself. Otherwise, on if you invest it in an industry, it will leads to a new service to the society. The new product will leads to a new service to the society. So, patent, what are the field where patent is granted? Patent is granted in the field of science and technology. Next, what is the criteria for patent? The patent, the invention passing the following criteria will get patents. As I said, novelty, inventive step, and industrial applicability. Now, what is novelty? Novelty, the invention should not have been published in India or elsewhere. That is, the invention, the subject matter, what you are having in your hand, otherwise your research paper, it should not be published in India or elsewhere. That is the thing. And the invention should not have been in prior public knowledge or public use in India. That is, the subject matter what you are having in your hand should not exist in prior public knowledge or public use in India. There is some exception for Indian applicants that once if you have published your paper, research paper, from the date of publication, within 12 months, you can't file. After that is within the time limit of 12 months, you can apply for a patent. So, novelty is the first criteria that you should pass to get a patent. And the novelty, how novelty is search is done in the patent office is the invention or the subject matter what you are having in your hand should not be published in India or elsewhere. That is, the particular invention in your hand should not have any prior public knowledge or public use in India. That is, if you have if you have published your paper, also you can apply for a patent, but within the after 12 months period, you can come and apply for a patent. Next criteria for getting a patent is inventive step. What is inventive step? Inventive step means a feature of an invention that involves technical advancement as compared to the existing knowledge or having economic significance or both, and makes the invention not obvious to a person skilled in the art. So, I'll explain it. What is inventive step? Inventive step means a future of an invention, that is the subject matter or your research or in your hand that should involve a technical advancement as compared to the existing knowledge. That is, some knowledge will be available in public use, and your paper or your research should be something technically advanced than whatever is there in the nature, and it should have an economic significance, and it should not make the person obvious to it should not make the invention, it should be not obvious to a person skilled in the art. And the question is there any inventive step arises only when there is novelty. That is, if your process or product is novel only, this inventive step question arises. So, inventive step is the technical advancement as compared to the existing knowledge, and it should be not obvious to a person skilled in the art. Last criteria is industrial applicability. That is, the product or process should have an industrial application. That is the thing. I'll just read it out. Capable of industrial application in relation to an invention means that the invention is capable of being made or used in the industry. That is, after getting a patent, it should be useful to the people. That is what it means. Next comes, so to get a patent, three criteria are very important. One is novelty, second one is inventive step, third one is industrial applicability. Now comes a section. All these patents, trademarks, and in short, all IP rights are covered by rules and regulations. That is sections and rules. So there is an important section, that is section 3, where some inventions are not patentable. For example, section 3A, that is invention, that is the subject matter or any process or something which is against natural law, frivolous or against natural law. That is a method of gambling. It is not patentable. Next one, discovery of scientific principle, abstract theory, and new property. One property exists in the knowledge. If you say a matter contradictory to that matter, then it is not patentable. And another thing, that is discovery of scientific principle, abstract theory, and new property. Next one is new use of known substances, not patentable. Third one is substance obtained by mere admixture is not patentable. Method of agriculture or horticulture is not patentable. Mere arrangement or rearrangement of known device is not patentable. I'll say an example for new use of a known substance. If you are taking any tablet, it is saying it will cure fever. Next, if you are saying it will cure some cardiovascular diseases, that is not patentable. And next one is substance obtained by mere admixture. If you are mixing some substance in water and it's just an admixture, it is not patentable. But when you are saying any synergistic effect for this chemical substance, it can be patentable based on the data provided by you. Next, method of agriculture or horticulture, that is method of harvesting, method of sowing, nothing is patentable. And even method of cultivating algae, mushroom, it is not patentable. Next, mere arrangement or rearrangement of known device, it's also not patentable. Next one is important section, that is section 3I, where any process for medical, surgical, curative, diagnostic, therapeutic on human beings or animals or plants to render them free of disease, to increase their economic value. These are not patentable. So section 3I of Patent Act says that any process for medical, surgical, curative, diagnostic, therapeutic process on human beings or animals or plants to render them free of disease. Either by using all these methods, the animal, human being or plant will be free of disease, or to increase their economic value. These are not patentable. For example, surgical methods are not patentable. Vaccination, immunization, diagnosis of any particular disease like typhoid, like that, any disease, it is not patentable. Administration of medicine, that is therapeutic, it is also not patentable. Based on the dosage form, we are administrating like that. These type of claims are not, these are not patentable. Next one, mere discovery of living or non-living substance, not patentable. Plants, not patentable as such. Animals, not patentable. Even in whole plant and animal or a part of that also not patentable. Next one is scheme or rule or method of performing mental act, not patentable. Presentation of information, not patentable. Computer program per se, not patentable, because these computer programs comes under copyright. Next, the last non-patentable invention is invention relating to atomic energy cannot gain a patent. So, invention related to atomic energy, no patent is given. What to do after getting a patent? An inventor can manufacture his product or process, sell his product or process. He can go for licensing. He can go for signing, cross licensing, improve with, after getting a patent, he can improve with further R&D, protect with patent of addition and a patent of addition is nothing but when you have a patent, you can do some improvement in the patent and you can file for another application, that is patent of addition. So there are 3 criteria for getting a patent. First, patent document is a techno-legal document which should be whole matter should be disclosed to the patent office. In return, after checking the novelty, inventive step and industrial applicability, patent is granted for a period of 20 years. And this, after getting a patent, you can go for manufacturing, selling, licensing, assigning, cross licensing, improve with further R&D, etc. And there are certain groups where patent is not given. Those comes under section 3 and section 4. Under section 3, different categories are there where discoveries are not patentable, method of treatment non-patentable, method of horticulture, agriculture not patentable, etc. And section 4 says that atomic energy, invention related to atomic energy are not patentable. Go to the next thing. For more information, you can visit our ipindia.nic.in and this is our office address. Next is, who can apply for patent? Any person who is true and first inventor or his assignee or legal representative of an inventor. So, any person that if you have a research paper in your hand, you are the true and first inventor for that particular research paper. So, you can apply for a patent. Next, you can assign to any other person. That is, through your guide, you can come for a patent. Otherwise, legal representative or patent agents. So many patent agents are there. You can approach them and you can file for a patent. And here, who can make, any person make an application either alone or jointly. Suppose if you are doing a research on behalf of your college, you can come in your name of your college or your university. So, who can apply for a patent? Any person who is a true and first inventor or his assignee or legal representative of the inventor can make an application either alone. If it is your own research paper, you can alone come and file a patent, or along with your guides via college, you can come and apply for a patent. Where to apply? For Indian applicant, place of residence, business, or origin of the invention. So, for Indian applicants, for us, our address for service is India, and you can apply in Chennai Patent Office. Totally 4 patent offices are there: Delhi, Mumbai, Calcutta, and Chennai. So, people residing in that particular area can apply under this for this side: Kerala, Karnataka, Tamil Nadu, Andhra Pradesh. They can file it based on the zone in Chennai Patent Office. So, where to apply patent? Can apply in Chennai Patent Office. Next, what to apply or how to apply? First, there is an application for patent, that is Form 1. Second one is complete specification or provisional specification, that is Form 2. Third one is declaration as to inventorship, that is Form 5. Last one is request for examination, that is Form 18. So, what is Form 1? Form 1 is the application for a patent, where you have to mention your name, place, title of the invention, etc. with the signature of the inventor. Next one is complete specification or provisional specification, that is your Form 2. Form 2 should start with the title of the invention, and this complete specification or provisional specification should explain your invention or the subject matter or your research paper in depth, in detail. That is the thing. And next one is declaration as to inventorship, that is Form 5, where the inventor that is inventor and applicant. If a student is the inventor, the college will be the applicant, like that. So both of them should sign. That is Form 5. Next one is request for examination. This should be filed separately because you should give a request to the patent office that kindly consider my application and you start examining. That is request for examination. What are the types of patent application? I'll explain this so that you'll get a clear-cut idea of the second part, what is Form 2. So there are different types of application. One is ordinary application. Ordinary application can be filed in two forms. One is provisional specification and complete specification. Second one is conventional application. Third one is PCT international application. Fourth one is PCT national phase application. Fifth one is patent of addition. Sixth is divisional application. Okay. Now I'll explain one thing in detail. What is original application and provisional specification and complete specification? This ordinary application is the application filed by Indian applicant directly in Indian Patent Office. That is the ordinary application. It is of two types. It can be filed in two ways. One is provisional, another one is complete. Now, what is provisional specification? Provisional specification is that right now, if you are doing some research in your subject and if it is halfway, you have not completed, you can file a patent today itself in the patent office. You will get the priority date and you will get an application number and the priority date. That is provisional specification. It will not be published. It will be there in the patent office. Next, from the date of filing this provisional application, you can file the complete specification within 12 months period of time. That is, from the date of filing the provisional specification, you can take 12 months period to complete your whole research and file a complete specification, so that you will get the priority date of the provisional specification. That is the importance of this, filing a provisional and provisional after complete. Next is convention application. An Indian applicant can, with the priority here, he can go and file in any country. So many conventional countries are there within 12 months period of time. Next is PCT international phase. That also an Indian applicant can go for foreign filing within 31 months from the date of filing in India. Next is PCT national phase. This also, after filing in any country, an Indian applicant, after getting a permission from India, he can file an application in any country, and within 12 months, he has to come to India and file a patent application. Vice versa. That is the PCT national phase application. Next, as I said already, what is patent of addition? You got a patent already. You are doing some improvement of modification and filing for the second patent. That is called patent of addition. What is divisional application? 2-3 inventions might have linked together. So the patent office will ask you to divide the application and file it. That is the divisional. The first application will be the parent application. Second one will be the divisional of that parent application. So here the important thing what I want to convey here is, students, research scholars might be attending this. Right now, if you have any invention or if you have any work in your hand, you can directly come and file for a provisional specification. That is the provisional specification where you'll get the priority date and application number with the date. And you can take 12 months period to do your work, and then you can come and file a complete specification in Indian Patent Office. Next one, what is specification? Specification is nothing but an application for patent which shall be accompanied by the specification describing the invention. It is not, specification is nothing but describing the subject matter of your research. That is describing the invention. That's it. Then specification, as I said, it can be provisional or complete. Then convention and national phase application should also be accompanied by a complete specification. So in just what is specification? Specification is a part where your subject matter or your research paper is explained in depth. What is provisional specification? It gives only the patent office wants only the outline of the invention. This is the benefit of filing a provisional. It should describe only the outline of the invention need not claim anything. So just in a plain white sheet paper, if you write your invention and file in the patent office, you will be getting a priority date. That is just describe the outline of the invention, and it gives time to an inventor or applicant to work on the invention even while obtaining the priority. You might be thinking, why is that priority so important? So because within this 12 months time period, anyone can come and file for a patent in the subject matter what you are having in your hand. So, and they might be getting the priority date. So, but when you have an invention in your hand, you can first file a application and get the priority date. So, and when you are working on under this for this 12 months period, if a particular person is coming and filing for a patent in this 12 months period, his thing will be get rejected because you are having the priority. That is the importance of getting this filing this provisional application and getting a priority. What is complete specification? Complete specification can be filed along with the original specification application or following an application accompanied by provisional, or it can be filed separately. You can start filing with the complete specification also. The thing is, it should describe the invention. And next important part is it should end with claims. So what is claim? That I'll explain. Because of this claim part only, the application, patent application is considered as a techno-legal document. Okay. Section 10, I'll just explain what is Section 10.4. Section 10.4 of Patent Act deals that every complete specification shall fully and particularly describe the invention and its operation or use and method by which it is to be performed. So, as I explained already, the complete specification should be explained in depth. And it should, second point is, it should disclose the best method of performing the invention, which is known to the applicant. Whatever thing you know about your research, you have to submit to the patent office. It will be kept confidential only for the period of 18 months. So, you have to disclose to the patent office the best method of performing the invention, which is known to the applicant and for which he is entitled to claim protection. Next, last part is it should end with claim. Claims are defining the scope of the invention for which protection is claimed. Next, last, it should be end with an abstract. The abstract should provide technical information on the invention. So, the important section in Patent Act is Section 10.4, where every complete specification shall fully and particularly describe the invention, its operation, use, and the method by which it is to be performed. Next one is it should disclose the best method of performing the invention, which is known to the applicant for which he wants to claim his protection. And last one is the claim part, or defining the claim part should define the scope of the invention for which protection is claimed. Last one is the abstract. The abstract, on reading the abstract, outside people, third person should come to know about the technical information on the invention. Okay, so what are the parts of the specification? The specification should start with the title, field of the invention, background of the invention, object of the invention, summary of the invention, brief description of the drawings, detailed description of the invention, claims, abstract, drawing. These are the different parts of the specification. It almost resembles the research paper what you are preparing only. It should start with the title. That is the Form 2. First page should start with the title. Next comes the next page. That is the second page should covers all the subject matter. That is, as I said, Section 10.4. It should disclose the total subject matter what you know. That is, it should have the field of invention, background of the invention, object of the invention, summary of the invention, brief description of the drawings, detailed description of the invention, the claim part for which it's a claim is a techno-legal part and for which protection is needed. Next comes the abstract. The abstract should give the full information because the abstract will be published. That is the reason the abstract should contains all the information. Next comes the drawing. Next is, this is another one part to a basic criteria to get a patent. That is National Biodiversity Authority. Suppose any biological material is disclosed in your subject matter, that is in your research paper. Research, if you are using any biological material. What is biological material? Biological material refers to plants, animals, etc. So if you are using any microorganism, plant product or any animal product in your research, you have to deposit and get a number, and that number should be mentioned in your specification. And next one is the source and origin of the biological material shall be also mentioned. Third one is very important. That is, if the source is from India, you have to get a permission from National Biodiversity Authority. That is, which is being mentioned, that is Section 6 in Biological Diversity Act 2002 states that if you want to get a patent for the biological material origin in India, you have to get the permission from National Biodiversity Authority. I'll just explain this. If you are taking any plant source like herbal extract or any seed or any microorganism present in the soil of particular area from India, then you have to go file it in NBA, get permission from them and file a patent. Both the things can be happen simultaneously. You can file a patent here. If NBA objection is raised by us, you can go and file for NBA. Otherwise, you yourself can file that I have taken this particular herbal extract from the plant or tree available in my area. So I am going for, I want to get an NBA permission. So if you are using a biological material refers to plants, animals or product thereof, including microorganism. The specification should, the depository number of the microorganism or plant animal should be mentioned in the specification. Mainly the source of the plant or origin of the plant or animal, anything should be mentioned. And especially if the source is from India, any part of India, if the source is from India, get permission from NBA, because Section 6 of Biological Diversity Act 2002 says that patent can be granted after getting the NBA permission only. Next one is the very important part is specification and claim part. That is specification I have already explained. Now comes the claim part. The claim must be particularly point out and distinctly claim what applicant regarding to this invention. That is, the claim part should point out what you are claiming. That is the subject matter. If you are having a new process in your hand, the claim should explain the process in detail. And if you are having a product in your hand, the claim should explain the product in detail. And the claim should defines the boundary of the invention. That nothing should be left out without claiming. So the claims should define the boundary of the invention. And as the same, the claim should be clear, concise, and a very important thing is it should be supported by the description. And the claim 1 is called as the principal claim, which should define all the essential novel feature of the invention or the subject matter or the research what you are having in your hand. So I'll just repeat it. What is claim? Claim is the part where actual protection is given by the patent office. Tomorrow, if someone is coming and saying that this is my invention, only the claim part will play an important role. So While drafting, the drafting of the claim should be done very carefully, and the claim should point out the distinguished feature of the subject matter in the hand. And the claim should define the boundary of the invention. Claim should be very clear, concise, and it should be supported by the description. Claim 1 is called the principal claim, and it should explain all the novel feature. For example, if you are having a process or product in your hand, the claim part, the principle, for example, take a process. If you are having a process of preparing a herbal extract, the principal claim should start from the process of preparing a herbal extract and the process steps, how it is preparing, how it is prepared. That is taking the source, that is leaf or something, and if you are mixing it with certain ingredients and bringing out the process, that total step should be explained in your claim, and that is the principal claim, which should explain all the essential novel feature. And the subsiding claim, that is claim number 2, it should start from the claim, the process as claimed in claim 1, the temperature used is like this, the pressure, etc. That should be the subsiding claims. And now, what is the claim? How the claim should be started? As I said, it has 3 parts. One is introductory statement, that is like an apparatus for shaking a chair comprises of a vehicle, a method, a composition. That is, the preamble has to be consistent with what is generally claimed in that claim. So, the principal claim should start as a method, a composition like that, and need not be too limited. It can be somewhat wide also. That is one example is given. Next is drawing. The drawing include illustration which facilitate an understanding of the invention. The drawing part you can explain by your illustration part, and by means of flowchart also a process can be explained, and necessary for the invention that claim a machine, device or article of manufacture. This drawing is very important for mechanical cases where when a machine is being claimed or a device or article of manufacture, it can be demonstrated only by drawing. Drawing must contain every feature of the invention that is being claimed, and the reference number should be mentioned in the drawing part. Next, I'll just explain what is the procedure we are following in patent office after filing for a patent. So first column is first box is filing a patent application. If you are filing a patent, it will be published within 18 months period. So the complete specification, what you are filing today will be kept secret only. Only after 18 months, it will come to public domain. Application number, date of filing, applicant name, inventor name, and the abstract will be published in the journal of patent journal. It will be published. And it is done in section 11A says that it will be published within 18 months. So within this 18 months time period, if you don't want to file a patent, you can withdraw the patent. That is the thing. And 18 months time period, it will be kept secret in patent office only. Then only after 18 months, it will come to public knowledge. In the meantime, you can file a request for examination. If no request is filed, then this is treated as withdrawn, like that. If request is filed in patent office and form 18, then it will be taken for examination. It will be examined and a report will be sent. That is called first examination report. First examination report along with the objections. That is, if any novelty, inventive step, industrial applicability, non-patentable objections are there, it will be communicated to the applicant or inventor. And once he reply back, if the controller is not satisfied with the reply, he will be given an opportunity of hearing. After the case is being heard, it will be granted or refused based on the merit. If it is refused, you can go and appeal in appellate board or to high court. Next, if it is granted, if the patent is granted by meeting all the criteria, novelty, inventive step, etc., if it based on the merits, if it is granted, then you'll get a patent for a period of 20 years, and the patent number, a 6-digit number, will be generated on the date, and it will be entered in the register of patent, and the patent certificate will be issued, and again it will be published in our journal. And this, for this 20 years of period, you have to pay the renewal fee of the patent. Next, after published, there is two type of opposition. One is before grant, there is a pre-grant opposition. That is, once it is being examined, anyone, if you see and if you come out with that, this is this invention I'm having in my hand, how you can apply for a patent. That is before grant. That is called pre-grant opposition. It also follow the same step. It can be allowed, not allowed, granted or not. Next, after getting a patent, if someone comes and argues that I am having a patent like this, how this patent is granted, then that time also there is he or he, that it can be opposed by post grant opposition. This is the general procedure followed in our patent office. That is a complete specification. First, if you are filing a provisional application, within 12 months you have to file a complete specification, or directly you can file a complete specification. This complete specification will be kept secret for an 18 months time period. After 18 months, it will be published in our official journal, and in the meantime, you have to file for a request for examination. If no request is filed, it will be treated as withdrawn. If request is filed, we will take it for examination based on the priority here also. Based on the date of filing, it will be taken and for examination. Right now, 2018 cases are being taken up for examination, and in chemistry group, they are doing 2020 request cases. So it will be taken for examination, and the objections will be communicated to the applicant or inventor. And if objections are not met, immediately it is not refused. An opportunity of hearing will be given. Based on the merit, the case will be refused or accepted. If it is refused also, the case can be challenged by the applicant or inventor in the appellate board or high court. Next, if all the criteria are met, patent is granted. Entered, you will get a patent certificate with a 6-digit number. Again, it will be published. There are two type of oppositions. One is before grant, one opposition is there. That is, any third person can oppose that this is my patent, my filing, my subject matter. In that case, it is called pre-grant opposition. After grant, it may be opposed by the third party. That is called post-grant opposition. Here, I'll just show some slides where you can just a minute. This is the claim part. For one invention for which patent is being granted, kindly refer this claim part. It should start with I claim or we claim. They are claiming for a micronutrient composition for supplying essential nutrient and promoting the growth in turmeric plant. Like this only the claim part will be. See the micronutrient composition, how they have defined. That is, what is the potassium content, magnesium content, zinc, boron, pH regulator. Next claim 2 is the composition, the micronutrient composition as claimed in claim 1. That is the claim part. That is claim number 2. More defining the claim 1. That is, it is giving only the range of potassium and magnesium. Next one is claim 3, which is again explaining the potassium content. Like this only. This I just want to show an example how the claims are being drafted by the applicant or inventor. This particular application is granted for the merits where this micronutrient composition in the description or specification, they have clearly explained the synergistic data, how this combination is formed and what is the advancement. They have explained everything in the example. So this is the claim part. Claim number 6, everything they'll that is the principal claim 1. They'll just give what are the components, what are the ingredients in the composition. Then rest of the claims they'll split it out and they'll explain. More on content. And see claim number 10. First claim is the claim 1 to 9 is the micronutrient, claiming a micronutrient composition and explaining the ratio proportion of the composition, that is ingredient. And it is being followed by claim number 10, which explains the process for preparing the particular composition. So this is the process for preparing the particular composition. And last one is the micronutrient composition kit. So this is the part what I want to explain. And this is the abstract. So the abstract should not exceed more than 150 words. And this is the abstract part where they have explained what is the micronutrient nutrient, what is the purpose of the micronutrient, and how the process for preparing the micronutrient. Last one is that particular case is granted based on the merits, and section 3E is raised for admixture based on the explanation given by the applicant or inventor, the synergistic data, and based on the explanation that case was granted. This is the case which was rejected in patent office because of a particular section 3P where traditional knowledge is not patentable, where traditional knowledge is not patentable. For example, they are claiming a particular method, a method for treating inflammatory bowel disease in a subject is human, comprising administrating to a subject an effective amount of extract of andrographics, that is nilavembu, and this one they are using for treating some inflammatory bowel disease. This was their claim. This is being rejected because the traditional knowledge of using this particular extract of plant, that is andrographics, is already known in the art. That so this is rejected, and not a patent is not given for this subject matter under section 3P. That is, if you go through the article, certain, that is, as I said already, these are the different documents which are cited for novelty. That is, article published in Journal of Natural Medicine, traditional treatment of gastrointestinal tract disorder in Kutch district, Gujarat state, India. That is, in Gujarat, India, they are using this plant for the treatment of this particular disease, which is traditionally known. So patent is based on that reason, patent is not given for this particular case. I think I have covered most of the part, and to explain the patentability criteria, I'll just give a gist of what I have thought till now. First one is, to get the patent, 3 criteria should be followed. One is novelty, inventive step, and industrial applicability. There are certain sections where patent is not given, that comes under section 3. And next comes the how to file a patent, who can file that, and all. I think I have explained it. How to draft a patent application, that is the important part. And students, research scholars, professors who are having a research paper should come out and file a patent. First, you should take some steps to file a patent. It is very easy. Patent office is ready to help Indian applicants and Indian applicants. So the part where you have to concentrate is that specification part. Either you can file a provisional or file a complete specification, which should be followed by the claims. Claims, I have given some example in the slides itself, how an applicant has drafted the claims. That is, he is claiming a micronutrient composition and a process for preparing the micronutrient composition. When you are claiming for a composition, it should be explained by the what are the ingredients they are using and what is the ratio of the ingredients and how the composition is being merged together to get a product. That is, the synergy between them should be explained in detail, and it has been followed by the process, and that is being patented, and I have given the reason for why the present case is not patented. I think I have completed all the mostly the subject matter and the topic given to me. Thank you all. If you have any doubts, you can just clarify. I'm ready to explain. I think, ma'am, I have covered all the parts in this presentation.
Yes, ma'am. Yes, ma'am.
Hope it will be useful for all the students and research scholars also. And I thank the management for giving me this opportunity. Okay, ma'am. Kindly ask some doubts. I'll clarify, because the only aim of me is to at least some basic information about patent should be passed to you, and you should come out with some invention, because we are granting a lot for India international applications. So many patents have been filed and people are getting patent, but Indian filing are very less, especially from our part. No filings are there. So the college universities also encourage the students, and you should file a patent. It is very easy procedure. Patent office there to help.
Ma'am, for sharing your expertise with us. It's time to express our gratitude. Now I call upon Sister K. Francie to deliver the vote of thanks.
A pleasant morning to all of you. Expressing your gratitude is one of the simplest yet most powerful things we can do for each other. Dear friends, I'm indeed glad to say a few words of thanks. First, I thank God Almighty for His blessings to have a fruitful webinar on role of IPR in innovation. I express my deep sense of gratitude to our resource person, Mrs. Hemalata, for sparing her valuable time to share her knowledge with us. Dear ma'am, your session was interesting and thought-provoking. I'm sure that our students are aspiring to be very innovative in their career and apply for patents after listening to you. Thank you, ma'am, for your patience and generosity in explaining IPR to us.
Okay, ma'am. Thank you so much, ma'am.
Thank you, ma'am.
Thank you.
I thank Dr. Sheba Daniel for her tireless effort to make this webinar a successful one. Thank you, ma'am.
Thank you, sister.
I'm glad to thank Dr. Lima Rose, our head of the department, and all the staff of our department for their constant support. Thank you, ma'am. A special note of thanks to all the participants. Thank you, dear students, for your interest in being innovative. I hope you will make use of all that you heard in your future career. Once again, I thank one and all. Thank you.
Thank you, sister. Dear participants, the feedback link for this webinar is posted in the chat box. Kindly fill the feedback form to receive the e-certificates. Thank you.